Welcome to the Tortoise and Hare Financial Podcast, where we unravel the secrets to financial wellness at a steady pace. Your hosts Jim Lao and Ryan Genoe have an eye-opening episode lined up as they dive into the world of estate planning with the help of the brilliant lawyer, Sonia Kociper. They'll be exploring an insightful article titled Your Estate Plan, Promoting Harmony and Preserving Family Relationships. This article brings to light some crucial aspects often overlooked in estate planning, such as digital assets and tax considerations. As technology takes center stage in our lives, many Canadians fail to include their online accounts and digital tools in their estate plans. We'll learn how to proactively address these complexities with the guidance of legal professionals experienced in digital estate planning. In addition to digital assets, we'll delve into the world of estate taxes and how they can impact your loved ones. Working with an accountant to optimize tax efficiency can ensure more money is left for your beneficiaries and charitable organizations. DIY estate planning can be tempting, but we'll discuss the importance of knowing when to seek professional help. Setting up trusts for disabled beneficiaries and strategic tax planning require expertise that's best left to specialists. A team approach to estate planning is crucial, allowing you to tap into a pool of knowledge, ensuring no critical details are overlooked. From tailored solutions to emotional support, we'll uncover the benefits of working with a team of professionals. And let's not forget about the importance of regularly updating your estate plan. Life is dynamic and circumstances change, making updates vital to align with your current wishes and avoid unintended consequences. Estate planning is for everyone, regardless of age or financial status. It's about preserving your legacy, protecting your loved ones, and leaving a positive impact on their lives. Join us as we navigate through this captivating discussion with Sonia Kociper and unravel the secrets to a comprehensive and effective estate plan.
Why is it me? Why am I that guy? I still buy low, still sell.
I'd like to welcome everyone to the Tortoise and Hare Financial Podcast. I'm Jim Lao, your host today. Joining me is one of my partners in crime, Ryan Genoe. Ryan, how you doing today?
I'm doing great. Thanks.
Good. And joining us today for a second time this year is another long-term partner of crime of mine, my business partner and lawyer, Sonia Kociper. Sonia, how are you today?
Doing great, Jim. Thanks.
Good. So today we're going to be talking about another topic that we really haven't touched on. One of the reasons that prompted Ryan and I to want to do this is, I'll use today as an example. I went on a nice morning hike and listened to some classical music in my earbuds. And it was just really a way of helping me kind of manage my stress. There's, trying to find different ways to manage stress. And then Ryan and I recently, actually our last podcast recording, we talked about a survey from FP Canada that surveyed about 2,000 Canadians, and 40% of them had indicated that their number one cause of stress was financial stress.
Yeah.
And then I started to think, I've had some recent communication with clients of mine, and there's another type of stress that many people don't really consider or think about until it actually they're faced with the issue. And one of the two is if an elderly loved one physically and or mentally is no longer capable of doing things for themselves, they don't have a power of attorney in place, that becomes quite challenging. And finally, if you're someone who's trying to settle an estate of a loved one, and they haven't planned properly and don't have, the wills and instructions in place, that's also another major stress that people have been facing lately. So Ryan and I looked at an article called Why Powers of Attorney, Wills, and Trusts Are Very Important. And that is why I decided, along with Ryan, to bring in Sonia to help us understand a little bit more about powers of attorneys and trusts. So why don't we start off, Sonia, with just basic, what is a power of attorney? What is a will? for those people who just don't really understand the difference of the two. So let's start off with powers of attorneys.
Right. And it is common. So if you don't know the distinctions, don't feel like you're behind the eight ball. It is common that a lot of people don't know the differences. So a power of attorney is a document that is enforceable while you are alive, and it allows someone else, namely your power of attorney, to make decisions on your behalf when you're incapable. There's various types of powers of attorney. There's limited power of attorney, specific powers of attorney for, let's say, someone wants to sell a home. And in that instance, it's because you're absent or you are out of the country or you can't sign. Those are different. We're talking about powers of attorney when it comes to incapacity and what your power of attorney can do and have control over while you're unable to make decisions. And the inability to make decisions varies widely. But if, there's a medical diagnosis that you have a certain condition that does not make you capable of making a decision, then that is classified as incapacity. And your power of attorney can carry out certain things for your well-being, always in the interests of your well-being. So they can carry out decisions with respect to property, real estate, investments, bank accounts, anything of that sort, except your power of attorney cannot make a will on your behalf. Your will continue to dictate. And there's powers of attorney over personal care. So if you need home care, if you need a surgery, if you need anything for your personal well-being, your power of attorney can make those decisions. Included in your powers of attorney, you can have very specific directions, such as some people include a DNR or do not resuscitate clause. Others wish to leave it at the full discretion of the power of attorney because obviously they're appointing someone that they fully and completely trust to take over their decision making when they're incapable. In respects to a will, well, a will is when you have passed on. Powers of attorney while you're still alive, and the distinction with a will is you have passed on, and now it's a legal document that is appointing an executor and assigning beneficiaries to receive the distribution of your estate. So an executor, let's take that back. An executor is someone that you appoint that can also be a trustee within the will, if there's trust provisions incorporated in there. And the executor is the person who quarterbacks everything. They're the ones that are now taking in all the instructions from the will, probating the will, carrying out everything that's necessary to be able to distribute the estate to the beneficiaries. So the executors are acting in the best interest of the beneficiaries. The beneficiaries are the people, your loved ones, who are receiving the estate at the end of the day. Real estate, all of your assets essentially are incorporated into there. And now I'm specifically speaking about personal individual wills right now. There's a distinction as well. If you own a corporation and you want to develop and create a corporate will, it's called an excluded properties will or a secondary will. We can talk about that as well if there's time.
Right. Okay. And with powers of attorneys, the one thing that does come up on occasion in our business with both Ryan and I, we'll have clients who, for example, have registered assets in RSP or RIF or even non-registered segregated fund or even life insurance. In most cases, and this seems to be more based on each company that's holding the financial instrument, but they will not allow a power of attorney to name themselves as a beneficiary. Now, up until recently, there were a few companies that as long as we had a will in place that identified all the beneficiaries, including the power of attorney, they would accept that. But now it looks like those companies are no longer allowing that either. So one thing to kind of keep in mind is if you are a power of attorney and you're trying to name yourself as a beneficiary on an account or insurance policy, it's going to be difficult to do so. I don't think there's any company now that will allow that for that to happen. But I'm not 100% certain. I just know there's less of them now than there were once upon a time.
Well, it's a good safeguard because the power of attorney has a lot of authority over your property over your accounts.
Yeah.
So it's a good safeguard for the
Yeah.
individual who can no longer directly communicate instructions to the company. So,
Right. Okay.
yeah.
So let me ask you this then. Let's use powers of attorney as an example. Let's say there's a loved one, your parent, typically it's an elderly parent. Mentally, they're not able to take care of their own affairs, or even physically, and there isn't a power of attorney in place. What happens?
Well, the threshold of what qualifies as incapacity is actually quite high. So if we're talking about where a physician has now qualified the elderly parent as incapable,
Yeah.
then what happens? Well, you are making a lot of decisions on behalf of your parent without any authority to do so. And the companies that you're speaking with will refuse to deal with you. So
Right.
even something as simple as withdrawing money from a bank account to support the day-to-day needs of your parent will become a big challenge. So now you're going to have to likely support your parent to on your own income, and until perhaps death, until a certain event occurs. Yeah, and depending on what the situation is, you can always apply to the courts to obtain this type of authority given the situation. But it's, time consuming, it's costly, and at the end of the day, it could be so easily rectified with a power of attorney. They can be so simple and so easy to do, and they're not cost prohibitive. They're not expensive at all.
Right.
And it's just a matter of, putting your mind to it, making sure that these things are in place, and, having conversations like this are very, very helpful, because then people become aware of it, the knowledge of knowing how important it is to put something like that in place.
All right. So basically, also go ahead, Brian.
I say I often find with clients these are some of the hardest conversations that they start having when it comes to powers of attorney and wills, because it talks about end of life and things that people think are either a jinx or something, but it really, in the end, it becomes such a heartache. And as you said, like it can become financial, mental health when it comes to those things. And, having these conversations, and Jim and I will have that as one of our early questions is, do you have a will or a power POA in place? That way we know where we're at when they prepare for their financial plan, right?
Yeah, for sure. And, and I'd have to think too, if someone, for example, owns a home and they have mobility issues, and now it's time to sell the home and they haven't listed a power of attorney and they're not able to, again, make those decisions on their own, that must be a very long process, again, to apply to the courts, to be granted the power of attorney authority, to then go ahead and potentially list a home. Like, that could be long and drawn out and, as you mentioned, quite expensive. So I would think that, kind of like with life insurance, when we talk about it with Ryan, with people, when's the best time to get life insurance? Yesterday.
Yeah.
When's the best time to get the power of attorney in place and the will? Yesterday.
Yeah.
So what happens then without a will? Someone passes away and there's no will. Yeah.
So the will being, once you do pass on, several things can happen. In my experience, where there is a next of kin readily available, then you, as the next of kin, direct next of kin, you can apply to the court for a certificate of appointment of a state trustee without a will. And then the court will provide you with the authority to be able to distribute the estate in accordance with the law. So the Succession Reform Act. It does not go in accordance with what was perhaps originally intended by the deceased. It is according to the law. So then, depending on whether, the deceased was married and then had children, etc. And it goes down a very specific list. With in the alternative, what can also happen if there's no direct next of kin, then it goes to the public trustee. So now we have the government in your affairs, in your financial and family affairs, and they are going to be distributing the will and charging the estate for all of the actions that they take and all the steps that they take in carrying out and maintaining, the estate until it is actually distributed. And if there's trust arrangements, then we get the public trustee involved as well. And now they're in the affairs instead of family members who know each other and know the needs of the family, etc. Now the public guardian, or I haven't even discussed the public guardian, but the public, trustees and executors are now, doing this. If there's children involved, a public guardian will step in if there's no guardianship provisions because there's no will. And your children can actually not go to the guardians that you may have originally intended or discussed, with family members and whatnot. If something happens to me, I want you to take care of my children. That's no longer in play.
Yeah, and that's one that actually comes up a lot when I'm dealing with younger clients. When I ask them about wills, powers of attorneys, have they put one in place? Many times it's all we've been meaning to, and we're going to get to it eventually. And they have, multiple children under the age of 10, for example. And I will say to them, what do you think is going to happen to your kids if you don't have a will in place? If both spouses pass away, who's going to take care of the kids? And they're like, well, I really would love so-and-so too. I'm like, but if you haven't written that down anywhere, then the government's going to decide ultimately who's going to take care of the children.
They could.
Right? Well, someone's going to have to make that decision. Now, you might be in a situation where it's just like, you know what, there's just one natural, obvious person or couple, and that's fine. But you can also have a situation where you have now families fighting each other, wanting to take guardianship of the children because they feel that they're better with them. And now it becomes a long, drawn-out battle.
Well, you mentioned something right at the beginning, and that was preserving family relationships. When we're dealing with money, guardianship of children, now relationships become a bit tender and trying. And so in setting up a will, expressing your wishes, laying it all out, you actually preserve relationships. You actually carry out the wishes that you want, and everyone attains sort of a more peaceful environment. That's what we hope. Sometimes, there's disputes on wills and things like that. But at least you too have the peace of mind that you have created this, and now everything that you have worked so hard for is going into the rightful hands of your loved ones.
Yeah. It's amazing how many times I'll get a couple say to me or an older, client, my kids are going to be fine. They get along. They're not going to fight. They will be able to sort things out themselves.
Yeah.
And I've seen it, once the death happens, emotions are raw, emotions are high, and there's always one person that goes way offside unexpectedly because we don't know how people are going to respond or react when it becomes a very painful, emotional situation, right? So it's just easy to just avoid all that. Just write a will, put it in writing, and that way it's very difficult to dispute that or to challenge that.
Absolutely.
Right.
And I have an example of when you don't have a will and, a loved one passes away. There was a common law couple, and the one of the spouses passed away, but they weren't legally married. They held their property, their real estate property, in tenants in common. So therefore, the deceased's share of the property went to his next of kin. He had children from previous relationships. He had 4 children. The estate, his estate, went to the children. It did not go to the common law spouse. She was forced to sell the house, move out with her own children. It was a nightmare for her. She had to, incur all of this. And she was also, she got, the appointment as executor. So she was carrying out everything, incurring all of the expenses until the estate could be probated and paid back to her. And it was such a stressful and sort of, financially altering time for her. Yeah. And it's terrible. And she should have really, if he had made a will, she would have likely received the estate, perhaps been able to, not continue living there, not have to sell the house, etc. But she couldn't afford not to. She had to in order to carry out the wishes of the Succession Law Reform Act now. Like, she had to carry out the wishes in regards to how the law dictated it. Yeah.
So bottom line, again, going back to when should you get a power of attorney? When should you get a will? When should you get life insurance? Yesterday.
Yeah. Well, my mentor...
my mentor... Don't wait till tomorrow.
Yeah. My mentor said to me, advise your clients that, if they don't plan on dying, then they don't need a will. And that's the only person that doesn't need a will.
Yeah, exactly.
That's it.
Well, no one really plans on dying. We just know it's going to happen.
Yeah. But if you don't plan on dying, that's it. So I always chuckle at that because it's so true. Everyone does need a will. Now, there's certain times where your will needs to be probated or not. But really, the question is, if you were to pass away tomorrow and your loved ones needed to access your money, would they be able to, even if it's nominal, even if it's under 50,000 or whatnot, would they be able to just sustain the day to day? And if the answer is no, then put together a will.
Right.
There's alternatives. You can add, your loved ones onto your bank accounts and other investment accounts and whatnot. But now things become joint, and that becomes a bigger strategy as to, tax planning and whatnot. But that's really the question.
That's kind of changed now.
Yes, right? I know. You told me.
Now that actually has changed, and I think the change happened back in 2017, where just simply having your name in joint ownership with your parent, for example, on a home or a bank account, no longer helps to avoid probate.
Right.
And really what the measure is for CRA specifically is if you were, so for example, let's say you had a GIC in joint name, which I've seen a lot. If the parent was claiming all the interest expense as income, and the joint child, for example, wasn't, then CRA will look at that and say, well, obviously this wasn't intended to be rolled over because only one of the two parties were claiming the income while alive. And they could challenge that and say, no, this is not going to avoid, this will not bypass, this has to go through probating. Or if there is no written record, so to your point, if the will states this GIC, certificate number, so-and-so in joint name with, is intended to go to the joint owner, then that potentially would help avoid probating. So there are some nuances now that have been added recently. It's no longer just simply put your name on and you're done, right? And you're safe. So I think people have to consider that as well.
Right.
Right. And another way to, I think some of the accounts that you can avoid probate with, and Ryan and I can speak to this a little bit more, RSPs, as long as you name a beneficiary on your RSP or your tax-free savings account, that doesn't go through probating. So there's no estate process there. Ryan, what are some other products that you and I work with that can help clients avoid probate and estate issues?
Well, a large one is obviously life insurance. Life insurance clears both probate and also at the same time follows exactly how you want it to be directed, kind of like a will, but it's unlike a will, it's not public, right? So it goes directly to the people that you intend it to go to without any fighting in behind. So there's lots of great options for people to avoid probate and to avoid kind of the in-house fighting, because every family gets along perfectly, correct?
Yeah.
Right. So yeah, one of the things that I was trying to figure out too is, obviously people have a hard time figuring out who to appoint in like the executor or the power of attorney, because as we were just talking about too, powers of attorney, you know, kind of creates a little bit of confusion and some upheaval when you're being a beneficiary at the same time. So how do people kind of think through that process too?
That's a great question, because it all depends on who is also willing to take on those roles. With respect to being a power of attorney, there's a lot of important decisions being made, especially if you have a more robust, wealth, and if you have more intricate sort of financial plans in place. It's a real significant position to be in. From the personal care perspective, powers of attorney have very important decisions to make. So someone that you really trust, someone that is rational, reasonable, and is not emotionally tied, right? They're going to be emotionally connected if you have a parent that's not well and whatnot, but that are going to make the best decisions in the circumstances. With respect to being an executor of a will, I have many clients right now who have sat for years and years and years in administering the will because it was so daunting a task that they just couldn't handle it. And in the process, one of my clients got ill as well, so they couldn't continue to handle it. There was no, alternative executor appointed, and so they couldn't pass it on. It was their obligation to fulfill. Now, there's certain ways to relieve yourself of that, but when someone is assigned this task, you want to fulfill it, and it's quite a stressful thing to be put onto you, to have to administer this will, administer the estate. Now, who can you appoint? Always ask the executor that you're appointing.
Yeah.
Ask them if they're prepared to, deal with investment properties and these investments and all this stuff. And, work with the professionals that have the knowledge to provide them background information as to, what needs to be probated, etc. And really get their approval before naming them an executor. Sometimes you don't have anyone that is willing to take on the role, or even family close to you. I have clients who are elderly, they've had no children, they don't have any family here. And, having family in Ontario is important because you have to be resident Canadian in order to be named an executor of the will. And, they name a professional that assists them. So I'm named in a lot of wills to carry out as the executor because they have no one else. And so there's all of these factors to really consider when you're naming an executor, because it is not a task for just anybody.
Yeah, it takes quite a while, and some recent examples that I've had of clients, I've seen clients right now. We're going on 2 years that they're dealing with some of the stuff that's going on with executing the will and whatnot, and it's amazing the time and effort that it takes. So really do have that conversation with somebody before they get a big surprise at the end when they're trying to perform the duties of your will and whatnot. So
Yeah.
And there's a couple of reasons why it takes as long as it does. One of them, and I'll use a very recent example, is people are putting a lot of their money, for example, into non-cashable GICs because they're safe and they're paying a high interest rate of return. They are cashable if there is an estate claim, but it's not immediate. It takes time. I mean, when I worked for one of the major banking institutions years ago and worked near the GIC department, it would take sometimes up to 2 years to get those non-cashable, non-redeemable GICs cashed, liquidated for estate purposes. So, one of the things that we encourage our clients to look at, and this goes back to from a probating point of view. I know, Ryan, you mentioned life insurance is one way,
Yeah.
but another way is also a segregated investment contract that's only offered through insurance companies. And within a segregated fund contract, you can name beneficiaries, as many as you want. I mean, I've had one client name over 12 beneficiaries, and you can hold GICs in the contract, or you can hold a portfolio, an equity balanced portfolio if you like. So there's different options there. And I know from some planning that Ryan and I have done with clients, we've had clients where they were holding, $1 million, $2 million of GICs at the bank, and they literally had $1 million or $2 million estate once they pass away. And all we had to do was take those GICs once they became available, move them into GICs, fully cashable, into a GIC that's held through an insurance company. The rates are very similar. You're not going to lose out on rate of return. And we've turned $1 million, $2 million estates into $0 estates just by making that one simple move. And there isn't a time limit in terms of it has to be in a segregated contract for a certain period of time for it to avoid probating. Literally, that takes into effect from day one once the account is funded. So, that's just one simple thing that someone can do to try to help avoid some of these estate issues and delays, because when there are delays, it means there's additional tax returns, there's tax liability, potentially could open up to claims against the estate. I've seen
By
that
the
happen as well.
beneficiaries. Yeah.
Right? Yeah. So that's, one of the main reasons why it takes so long to settle an estate is because of the investment decisions that they're making. The second reason is because a lot of times, I mean, I've had clients of mine who've become executors. They are named as executors. They are aware that they are executors, but they don't have a record of where everything is. So they're literally waiting for statements to show up in the mail in order for them to try to settle the estate. And, one of the things that Ryan and I have encouraged our clients is record everything, try to centralize everything as best you can.
Yeah.
So that way, if something is to happen, the executor can step in and, is aware, has the records of everything. And I'm not just talking financial records. I'm talking about, where is the will? Where are all those records? Is there a trust in place? Where are all the investments? What liabilities? A list. Because another thing that an executor would have to do, Sonia, and correct me if I'm wrong, they're the ones that are contacting the utility companies to close the utility accounts, right? They're the ones that are, contacting, the phone companies. Like, that's their responsibility as part of being an executor. So
Yeah. And
a big
paying
part
out
of it,
the debts.
yeah.
And
And who becomes or usually comes to me wanting to have an estate plan? An executor who's had to settle, their parents' estate.
yep.
Yeah.
And they'll come to me and say,
Absolutely.
I didn't realize how much work is involved. I had to take time off of work to deal with these things. There was travel because sometimes, you can be, a parent could be across the country or the child, the executor could be across the country. So now there's travel issues. And so they'll come to me and say, I need to speak with someone so I can put together an estate plan because I don't want my children to have to go through what I just went through with my mom or dad.
Yeah.
And
Well,
that's when I turn around and I say, you need to talk to Sonia.
Yeah. And I've had clients where an executor, they know they're an executor because they're a beneficiary on a policy, and they've called me, and sure enough, because of my relationship with the client that's passed, I have copies of some of the things that they need that they don't realize that they need. And,
Yeah.
I have checklists of things of here are some things to go through. And, rest assured that person was very grateful that they were able to not only get the most recent copy of a will, but some recent documents for them, not only close out the life insurance policies and help them, get a little bit more direction on being the executor. So,
yeah,
Yeah.
absolutely. And that is one of the most important things of working with TVH is that if we have a client who's preparing a will, and I know that they're working with yourself, Jim and Ryan, I will incorporate that into the will. So I will state, please consult with my financial advisors and state their names and their contact information so that they can reach out to you. I always advise them, just do a cover sheet of just your basic, like just the account number and the name and who it's held with. And this way, at least you can update that yearly and have that tagged on. But if, for instance, they're working with you, you would have all that information because year to year, like myself, because I am a client of financial, we do a yearly update and you have all of my updated information. So an executor knowing who the financial advisor is can just get that. And I try to incorporate that into the will so that it's easier for the executor to have this information, to be able to pay off the debts, etc., and then distribute the assets of the estate.
Yeah.
And you were saying the individuals who come to us and really want to put this proper estate planning in place are the ones who've experienced it. Well, experience is knowledge and knowledge is power. Yeah. So let us share this so that you can now gain from our experience and our knowledge so that you have the power and the control to dictate what you want to do with your estate. Having worked our whole lives to create wealth, to pass it on to the next generation, to assist them, it would be such a shame to see all of that just distributed in a different way or controlled by, a public trustee, when you can really take an active role in ensuring that it's done properly. And you were mentioning there's other ways of distributing the estate through seg funds, through other insurance products, etc. And in working with TVH, you can really get the different strategies applying. I would still draft the will because not all assets are going to be captured in those other strategies that you implement. For instance, real estate cannot be captured in there. So we'd still need a will, but there might be a different strategy that we can implement with a real estate, maybe a family trust, maybe something else, so that, we're working in implementing the right paths, the right strategies so that our clients can really reach their goals and even past, even in their death. They can really ensure that their wealth is being distributed to the people that they want it to be distributed to. And, it's so important.
So putting a will in place, as you're talking about, will maximize and make sure that, the assets are distributed according to the wishes of the individual. Part of the estate planning that Ryan and I do, aside from maybe we want to put funds into a segregated fund contract or, have some insurance for the distribution, one of the things that we identify using a program like PlanWorth is what's the actual tax bill when someone passes away. And it's amazing when Ryan and I take a client through the process and they see this big red number and they're like, what's that? Right? So Ryan, do you want to speak to that a little bit?
And it's very simple because it's there in big red bold letters. And every client that we've done, especially clients that are, older, that are preparing for retirement or in retirement, and they look at this number and realize, I didn't realize how big a cut either the government or probate is going to take out of my bottom line, how hard I've worked for this, and what is not going back to, my family or, a legacy or perhaps a charity. It's funny to see the reaction, but also concerning because they think, oh, probate, it's just a small cut or whatever. It's not a big deal. But when you actually see what the number is based on what you've built over years and years of hard work, it is quite shocking. But it's not just
the probate cost, Ryan.
Yeah.
Right. Like when they see the other number and they're like, well, what's causing that tax problem?
Yeah.
Well, that's all your registered accounts.
Yeah.
Because it's amazing how many people, either when they talk about retirement, they think that their income from their RSP is tax free when they retire. And we're like, no, it's fully taxable. And not only that, when you pass away, and if there's no spouse to roll those funds to,
Yeah.
CRA will deem that you'd had disposed that account the day before passing.
Yeah.
So if you had, for example, a $200,000 RSP or RIF account, and you are the second in the marriage, and there is no spouse to roll that money to, well, that $200,000 is going to be deemed as it was cashed out the day before, which means that income gets added onto any other income in the year, and you're going to, half of it's going to go to CRA. And many of them, in their mind, thought, no, that account's going to my children or my grandchildren. And then we talked to them about, no, here's the net number. So the question that they'll ask is, well, how do we avoid that? And what we'll say to them is, get some insurance. Like, pass that tax liability to the insurance company. So instead of losing, let's use a small number, $100,000 to taxes, buy an insurance policy that's $100,000 in value. You're still going to pay the $100,000 in tax, but it's going to be replaced with $100,000 tax-free payout from the life insurance policy. So your net number still remains the same. So then the question might be, well, why don't I just, who cares if I lose it, or why shouldn't I just build up a savings plan to help offset that tax? Well, if you're paying insurance premiums, life insurance premiums, and if it costs you $50,000 in life insurance premiums to get that $100,000 to pay the tax, that's better than $100,000 out of your own assets to pay the tax. It's still cheaper by $50,000. So these are some of the things that Ryan and I, when we, bring a client through or walk a client through the retirement plan, we look for that number. We identify those numbers. And where it becomes even a bigger number is for people who own rental properties. So the program will actually not only calculate what the probate cost will be on it, but what the projected capital gain tax will be on it. Because again, when you pass away, that's going to trigger a tax event. So these are the things that people don't really consider when looking at estate planning. And those are the things that Ryan and I help our clients with. And then finally, with PlanWorth, we also have a program where we allow clients to upload a lot of their financial documents, including wills and powers of attorney. So even if they're not working with you, Sonia, and they've had other lawyers put those plans in place, we now are offering them a centralized location where they can upload all of their documents. It's stored there. So if an executor were to call and we have the authority to provide them with the information, it makes it so much easier for the executor, because it's like, here's everything. They can upload their utility accounts, their phone accounts, whatever. So that way they'll have access to social media, passwords and login credentials.
How about digital assets?
That's exactly it, right? Yeah. So that's something, in working with TVH as a team, we are able to handle not only the POAs, powers of attorneys, and the wills, and making sure that things get distributed according to how the individual wants, but we're also looking at, from an overall estate tax planning point of view, how can we structure things in a very efficient way to make sure that the loved ones actually get most of the wealth that's been accumulated throughout the years, and less to the tax person, the tax man. Yeah. Right. So that's part of the benefit of working with us, and we communicate with each other too within the team.
Well, it's a joint strategy, and that's one of the things that I want to ask you about. I'm converted. I know what it's from a client perspective, what it's like to work with the whole team, and to have the different strategies, the different options being presented to me, so that I can now make decisions as to what is the best route to take. But what is your biggest hurdle in communicating this? Because it all makes very good sense to me, to canvas the options, to put in the proper strategies. What is your biggest hurdle?
I think really, informing clients' awareness is really the biggest hurdle, to be honest with you, because you recently referred a client to me that I spoke with recently who had no idea that placing the proceeds of the mom's home in a GSE at the bank would have this major estate issue or problem. And yet, if we did the same thing through a segregated fund contract, we avoid all that. So it's really just informing people, getting the message out to a lot of people. And one of the reasons why we're doing the podcast, right, is so we can talk about it. Ryan and I send out a lot of social media content through Facebook and Instagram and LinkedIn, and some of it has to do with estate planning and the benefits of working with segregated fund investments or insurance. So really, it's awareness, trying to get the message out there is the biggest hurdle, because once people sit down with us and we go through some of these points, every single person without fail would say, I had no idea. I didn't realize it worked that way.
Yeah. You don't know what you don't know.
Yeah. And the other thing too is the banks, and not to make, to beat on them. I'm a former banker myself, but
So
once
am I.
once upon a time, you were allowed to simply put a person joint name on an account, and that avoided all these issues. That's no longer the case. It's not as simple as that anymore. It could, but it's not clear cut. So there's a lot of misinformation that's out there. So really, it's just the awareness.
Yeah.
Ryan, anything else to that?
Yeah, misinformation and listening to people that are still stuck in 1980 information, right? And again, as you said, people that have never experienced actually going through the executor portion of somebody passing, and how hard it can be, and how really sitting down and talking with the right people, us, is a great option to clarify everything, understanding each and every step, and how easy it can be for us to just take away a lot of that stress away from when somebody passes. And I've every client that I've ever had that I've dealt with their family members, and talking with them after, I've just been so grateful that I've been there to support them both emotionally, but also to make every part of that transaction and tradition or transition very, very smooth for them. So talk to people and find the right information. So.
And see, Ryan, back in the 80s, we had Tic Tacs, which were bad for the teeth. Now we have TikTok, which is bad for the brain.
Yes.
a lot of misinformation that's out there.
Talk about misinformation for sure.
So one thing that also is powers of attorney and wills, and you've joined me on calls with clients to kind of help guide them through, and one of the things I've dealt with in the past is lawyers always wanting to just push and say, yes, you need a will for everything. But I've seen you also have conversations with people saying, you know what, this may not be the right time for you because they're much younger, they don't have asset and stuff like that. So it was, having just got off a call, it was a breath of fresh air to hear some clients say that. Is like, it was surprising, and it was so nice to hear from a lawyer, and how nice it was talking with you, that wills may or may not be for everybody at certain stages. So I guess my question is there something you want to mention to people of when is kind of the tipping point for wills or powers of attorney? You actually kind of said powers of attorney is always a good thing, kind of right away.
Yeah. So powers of attorney, I would say, have them in place right when you're, the age of majority, really.
Yeah.
Because after that, like before that, your parents can make decisions for you. But after that, you're an adult. So you need someone, guiding that decision. But with respect to wills, if you really don't have any assets, there's really no reason to have a will. It's when you start accumulating assets, when you start creating a financial plan, or you buy a property, and definitely when you have children. These are the markers to when you should have an estate. And the question, again, like I said earlier, is if someone needed to access my money, because it's not a joint account, for instance, with maybe a partner, or parents or anything, if it's not a joint account, shared in the way the CRA will accept as a joint account, as per Jim's advice, then if someone needs to access your money, can they? If you don't have a will, that's really the question. And if they need it and they can't access it, well, then you likely have to have a will in place.
But what about in a situation like, I mean, I think a lot of people believe that you only need a will if you have assets. But what about an example where young couple or a single parent, with a young child who may not have assets because they're renting and they're starting off in life, but they have a child that if something were to happen to them, they'd want instructions on who would take care of the child. So in that case, or
as soon as you have a child, you want a will.
So it's not just because of assets.
No.
Right? I just want to be clear about that.
Yeah. Assets.
Right?
So the triggers would be having an asset. And I mean a bank account with money in it that someone else needs to depend on it if you were to pass on suddenly. And if you have a child. So your child, you need the guardianship provisions, especially if in your example, you're a single parent or if something happens to both parents simultaneously. Having the guardianship provisions, they're very, very important.
Okay.
And without them, and without having a direct next of kin who are, agreeable to taking on guardianship role, it just becomes very sad.
Right.
That where the child ultimately gets placed, and you just don't want that for your child. I don't want that for my child. Yeah. So, but having these things again it is so cost effective to have a will in place, because they're so important. My fees are very low when it comes to putting together a will and a power of attorney. It's very important to have these things to always create the peace of mind for yourself, but also the peace of mind for your family should something happen to you. And especially if you're, the financial, breadwinner and all of these things. What happens if you pass and you don't have a will? And I see this all the time. Right. People put their wills on the back burner. See all those purple files behind me? Yeah. They're all wills where I need responses to, and many, many more. People just don't carry out because, well, they don't expect to die. And I get that, right? We're invincible. We're going to live forever. But this is just the reality. Puts it out of your mind. And should anything ever happen, now your instructions are clearly there.
Yeah. The conversation about the estate planning talk is always an important one when bringing families together. And so everybody truly understands what's going on with the estate, the will, and that it's being planned. Who are the executors, understanding what happens with the kids, and that way having that open communication with the family. I know trying to break some things that are ingrained in a lot of families is not being able to have these conversations, and it is very difficult. And I've had them and helped families navigate through them. I know we're happy to have the conversation with the larger group family to make sure that that everybody understands and can ask questions, that people are coming to the table with all their questions answered throughout the whole process. So
we don't tiptoe around the topics, and they're very straightforward. My daughter asked me the other day, "Mom, how do you talk about wills and dying with people? Like, isn't that a touchy subject?" And I'm like, "No. Because if you think about it, we're all going to die one day." And I said, "No time soon, kid. But, we're all going to die one day. And wouldn't you rather make sure that all of your affairs are in order? Or do you just want to leave them, throw the sheets up in the air and that's that?"
It's like WrestleMania.
See, if my kids ask me that question, how do I talk about those things? With a Grim Reaper outfit. So we're gonna start winding things down shortly, but one last question for you, Sonia, which I just thought of. Why should someone work with a lawyer on POAs and wills and not a DIY kit?
Oh, good question. I get this often because we're able to really discuss the setup of the will. We're able to discuss things like, did you chat with your executor about taking on this role? And we're able to discuss the particulars of their situation that maybe they didn't think was important to put in because, again, they just didn't have the knowledge or experience to know that it was something that they needed to touch upon. So, for instance, do we need to put in testamentary trusts within the will because the children are minors and you don't want them getting $3 million when they are 18 years old because they're going to go buy shoes?
Yeah.
Like you don't want, we have those discussions so that we can put in thoughtful provisions that the client hasn't thought of, and we can ensure that all the bases are covered. I had a question the other day. We drafted up a will, and the clients wanted to put their children, who are still minors, as secondary executors of the estate once they turned 18. And the question to them was, well, what happens if your spouse, your primary executor, dies and your children aren't 18 yet? There's no executor. Now it goes to, potentially the state again. And we had to incorporate, that discussion to have an alternative in this instance. So there's opportunity for discussion, being very specific and detailed as to your situation if it requires it. And doing it as a DIY kit, you're not going to know the questions to ask or the information to put in there. It may be, a good shell, but it's not going to account for the things that may be necessary in your life.
Right. Or you might want to talk to them about how they might not want to name their 70-year-old mother as a guardian of the 7-year-old kids because, she's getting older. And of course, mom's going to do the best that mom, because they raised the individual.
Absolutely.
Different life stage. Or might want to name the trustee different from the guardian. Right. So someone's managing the finances and someone is taking care of the kids. Right. Because I know I've seen personally when you name the guardian and the trustee as the same individual, how all of a sudden the money runs out fairly quickly. Right. It happens. So
or even the residency status of the executor. Resident Canadian is a requirement. Because, and most people don't know this because I have this right there in my wills questionnaire, is your executor a resident of Canada? If not, please advise me. Because what happens is, let's say you have $1 million estate. If the executor is not a resident Canadian, they have to put up a bond in the amount of $1 million. Does everyone have access to that type of, financial capability? No. So then what happens? The will is, it sits still. Or you have to apply to the court for, a waiver of that bond, etc. And it becomes another sort of hurdle to surmount.
Yeah, we worked on a case like that recently, and we were able to help them kind of address that issue.
There's ways, but again, time and effort when things can just be more streamlined. To get to your ultimate goal, which is to provide your family with, the next level of wealth, or make sure they're okay, or, just peace of mind that they'll be okay now that you have passed. So,
well, you know what, Sonia, we're approaching the 1 hour mark. Normally our podcast lasts about 45 minutes, but this has been like a really engaging conversation. I think very informational, and there's other topics that we haven't even touched on. So maybe we'll have to have a follow-up episode to discuss some of those topics as well. So if anyone has any questions or is looking to have an initial consultation on setting up a will or power of attorney, what's the best way for them to reach you?
You can reach me by email, legal, legal, at tvhgroup.ca, or feel free to call us anytime, myself or my clerk Selena, 647-427-8486. We make the process very simple. so that we can get the will in place and have this peace of mind for your financial and well-being for your loved ones.
Great. Ryan, any final thoughts, comments, questions?
Wills, powers of attorney, get one if you haven't, obviously, based on the information. Don't be afraid to have this conversation if you are. Obviously, there's professionals like us that are out there to help you navigate this very difficult conversation, but it's a lot more difficult when it doesn't happen and something happens. So, but yeah, that's pretty much it. So.
Awesome. And if anyone has any questions or would like to reach out to Ryan and I, we can be reached at financial@tvhgroup.ca. Our number is 647-727-4668. You can also find us on the web, tvhfinancial.ca. Finally, you can also download our TVH Financial mobile app available for iOS and Android devices. Just look for TVH Financial. I'd like to thank you once again, Sonia, for joining us today for all the information. Ryan, thank you again. And we will be talking soon. Everyone take care.
Wonderful. Bye now.
Bye.
Why is it me?